The 15-month-old infant plaintiff was brought to a hospital emergency room and while waiting for treatment stood next to his mother in the crowded waiting area. At the same time, a 5-year-old child and his sibling were running around while their mother was with another sibling resisting treatment or receiving treatment. The 5-year-old suddenly pushed the infant plaintiff, who fell and fractured his elbow. The primary issue on appeal is whether the hospital can be held liable to the infant for injury. Plaintiff mother testified that when she and her infant arrived at the hospital, they were directed to the triage area of the emergency room, which she described as many rooms around with certain children. Then there were beds that you are able to close so that the children didn't fall out. And then in the center, there was a desk with many nurses on it. After a period of time, plaintiffs were taken to a small room with a chair, a desk, and an examining table where a nurse took the infant's vital signs. They were then directed back to the open central area, which plaintiff testified was not like a waiting room, doesn't have chairs or anything, where plaintiffs waited for medical attention. While they were waiting, another mother arrived with 6 children. When one of those children, accompanied by her mother, was taken to a cubicle, the other 5 children, left unsupervised, were horse-playing, running around and climbing on the beds. It is undisputed that the triage nurses more than once instructed the children to stop running. Nevertheless, one of the children, approximately 5 years old, ultimately ran the plaintiffs and pushed the infant plaintiff, who fell down and broke his elbow. A hospital has a duty to protect patients from injury. See New York versus Cabrini Medical Center, 97 New York 2nd, 247, 252 to 253, 739 New York Supplement 2nd, 348, 765 New York Supplement 2nd, 844. Freeman versus St. Clair's Hospital, 74 AD 2nd, 300, 548 New York Supplement 2nd, 686. Concomitantly, an owner or possessor of property has a duty to maintain the personnel in a reasonably safe condition for those who are lawfully present. Nallen versus Helmsley Spear Incorporated, 50 New York 2nd, 507, 519, 429 New York Supplement 2nd, 606, 407 Northeastern 2nd, 451. Williams versus Citibank, 247 AD 2nd, 49, 51, 677 New York Supplement 2nd, 318, leave denied, 92 New York 2nd, 815, 683 New York Supplement 2nd, 164, 705 Northeastern Reports 2nd, 1215. While the dissent recognizes that this case involves the hospital's alleged breach of duty in this regard, it argues that the hospital does not stand in loco parentis to the infant plaintiff. That is clearly not the theory on which liability is sought to be asserted against the hospital. One acting in loco parentis has the duty of exercising such care of his charges as a parent of ordinary prudence would observe in comparable circumstances. And there is no claim in this case that the hospital was under such a duty. Thus, to be entitled to summary judgment, the hospital was required to establish that it maintained the area in which the accident occurred in a reasonably safe condition C. Westbrook versus W.R. Activities, Cabrero Markets, 5, Appellate Division 3rd, 69, 773, New York Supplement 2nd, 3840. It has failed to meet this burden, nor could the benefit do so, or the hospital do so, in light of the undisputed evidence that the nurses were aware of the presence of unruly children, but neither called security nor took any other means or measures to keep them under control or insulate the infant plaintiff from a physical encounter with them. Merely warning the unruly children to behave was clearly insufficient. The dissent asserts that no reasonable provision of additional supervision would have prevented the occurrence. This conclusion not only usurps the jury's function, but also ignores the fact that the accident might arguably have been averted if the nurses had called security or if something had been done that was available. How's that?